not offered for the truth of the matter asserted. In court, you cannot simply repeat what someone else said and expect it to be treated as proof. This is called hearsay, and it is generally not allowed because the original speaker isn't there to be cross-examined. However, you will often hear the phrase, "It's not offered for the truth of the matter asserted." This means the statement isn't being used to prove that what was said is true, but for some other legally relevant reason. Now, if that's not clear, let me help. Under Utah Rule of Evidence 801C, the analysis turns on the purpose of the evidence. A simple test is this: if the statement were false, would it still matter? One proper use is the effect on the listener. For example, if a husband testified that his wife threatened to take the kids, it might be offered to explain why he immediately filed an emergency motion, not necessarily to prove she intended to do as he accused. Another category is verbal acts, where the statement has independent legal significance, like an offer or a revocation of consent. Sometimes statements are allowed just to provide the context to make other evidence understandable. In custody disputes, Rule 803.3 allows statements reflecting a person's then existing state of mind or emotion, such as, "I am afraid." However, it does not allow statements of memory used to prove past conduct, like, "I am afraid because he hit me." In bench trials, judges are presumed to be able to compartmentalize this evidence. But doctrinal drift can occur when limited purpose evidence starts being used to support factual findings. Evidentiary discipline protects the integrity of the case, or at least it should. The question always remains, why does this statement matter? If it matters because the court is being asked to believe it is true, the hearsay rule applies to ensure that findings rest on reliable, tested proof.